Everyone has heard of Miranda rights. If you have lived any time in the United States and watched any TV or movie program where someone was being arrested, you can probably recite most of it with me. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you can't afford one, one will be appointed to you. So Miranda is a very important case, and it is used every single day in law enforcement. And what is it about then? So before Miranda, that is the case, Miranda, the judge's court system would review confessions with sort of a totality of the circumstances. What they were looking for was whether or not the confession was voluntary or if maybe the internal volition of a human being had been overcome. Voluntariness was determined by whether the subject's will was broken or had been overborne. So Miranda, the case, absolutely rejects this voluntariness as the sole test. So it doesn't reject voluntariness as part of the test, but as the sole test. So now there is a 3-question framework. So it's not just, hey, was it voluntary, and here's the evidence that it was voluntary. We have 3 questions, and they all must be answered in the affirmative. Were the Miranda warnings given? Yes or no? If they were given, was there a waiver? Yes or no? If there was a waiver, was it intelligent and voluntary? So it's not merely the case that giving the Miranda warnings is enough. There also must be a voluntary and intelligent waiver of rights. And oftentimes that is documented in writing, although it doesn't have to be. So the basics of Miranda v. Arizona. Here was the issue. Here was the issue before the court. Must a police officer inform a suspect who is subject to a custodial interrogation? Must the police inform this subject, either his or her rights, of the constitutional rights involving self-incrimination, that is the right against forced and self-incrimination, and the right to counsel prior to questioning for the evidence obtained to be admissible in court? That's the question. So, when must the Miranda warnings be given? Well, the short answer is, whenever there is a custodial interrogation. Just break it into 2 parts. That means the suspect is in custody and the suspect is under interrogation. So, when does custody occur? Well, the easy answer is, whenever the suspect has been arrested. If a suspect has been arrested, it is very highly likely that that person is in custody. That's almost the definition. But there are also lesser restraints that can count as custodial. That is, someone being in custody. If a suspect is not technically under arrest, but is, quote, deprived of freedom in a significant way. And that obviously leaves us up for more interpretation. Well, what does that mean? What does it mean to be deprived of freedom in a significant way? But that's what we're talking about in the first leg, which is in custody. Interrogation occurs when the police are asking questions that tend to incriminate. Now, that also, if you're already thinking like a lawyer, what does it mean to tend to incriminate? Because a question could seem sort of a normal, neutral question, but the answer to that normal, neutral question could also tend to incriminate. And in cases that I have been a part of recently that had to do with a civil and a criminal case at the same time, the case law on this, almost any question could tend to incriminate, at least from my view. So specifically, though, when police ask questions that might tend to incriminate someone. Second is the police are asking no questions, but through their actions, they're creating a functional equivalent of interrogation. So even if you're not using words, but you're using actions, it could be the case that it would fall under the category of interrogation. So there are certainly a lot of decisions. That is, after Miranda, there have been additional Supreme Court decisions that help sort of shade in, color in the right and when it should be applied and how it should be applied, and, well, that one doesn't count. Well, that situation does count. Those kinds of decisions. So situations in which the Miranda warnings must be given have been more expressly written about. The situations not requiring or not fully applying the Miranda warnings have also been sort of sketched out in these leading decisions, and then also situations where Miranda warnings are just simply not needed. It may seem like on its face, well, we need to have Miranda warnings, we didn't have them, so this should be excluded. And the Supreme Court says, well, yeah, not in that situation. So that's what the additional decisions, that is decisions after Miranda that are indeed focused on Miranda, have sort of given law enforcement, prosecutors, defense lawyers, judges, justices. That is what we have on our plate today. So one of these areas where the leading decisions have created some maybe safe harbors is when there is no need to give a Miranda warning. So first, when the officer does not ask any questions, right? If a police officer is not asking any questions, no warnings need to be given. During general on-the-scene questioning, personally, I take issue with this. Although we're gonna lean on the Supreme Court and go with what the Supreme Court has said. I think even general questions can tend to incriminate, and I think there's at least an argument here, perhaps not a successful one before the Supreme Court. But if it were me, if I were giving instructions to a law enforcement officer, I would say you shouldn't have to do this every time because it's going to freak someone out, but there's a possibility that if you ask questions and you think they're general, a defense lawyer might not think they're general. A judge may not think they're general at some point. But typically, the beginning of the conversation, general questions, you don't have to give Miranda warnings for that. In fact, if you did, it might be harmful for the case. What about when the statement is volunteered? So imagine someone goes up to a law enforcement officer, says, Officer XYZ. And it's a voluntary statement. It's either admission or a full confession. The officer didn't have the person in custody, wasn't even asking any questions. It was volunteered to the officer. No Miranda warning is required for that to be admissible. When law enforcement is asking questions of suspects, sort of routine identification questions, not needed. What about when you're questioning witnesses who are not suspects? Also, I think this is tricky. If you're questioning just witnesses, at some point it could turn to where that witness becomes a suspect and questions can move beyond. Obviously, there's always going to be an argument from defense counsel. It might or might not be meritorious, but generally you don't need to give a Miranda warning if you're questioning witnesses who are not suspects. Perhaps an eyewitness to a traffic accident involving a DWI. Well, the person driving while intoxicated is the suspect, but we also want to see what happened. Was anyone else potentially at fault? Was there another car? Who was injured? Those kinds of questions. No Miranda rights are in question here, and no Miranda warnings must be given. Another module on stop and frisk cases. You should already know about that, but again, shows up here. No Miranda warnings are required. Also another module on lineups, show-ups, and photographic identification, and no Miranda warnings are required for those three categories of identification. When a statement is made to a private person, well, that makes sense because a private person is not a police officer. Now, there could be some weird facts where the private person is later shown to be an agent of the state, and then maybe warnings were required, but just generally a private person doesn't require it. And jump down to the end when an undercover police officer poses as an inmate and asks questions. In that case, it actually is a police officer, but the suspect or the subject of interrogation doesn't know it. So not required. When there's a threat to public safety, it's not required, and in the context of a grand jury, it's not required. Finally, this is an important part of Miranda case doctrine. It may not mean a whole lot to you, but as an appellate attorney, standard review is king, and the kinds of review that courts of appeals and Supreme Courts apply is sometimes dispositive. That is, if you apply one standard of review, one side wins. If you apply a different standard review, the other side wins. So the kind of review that you apply, the level of scrutiny perhaps that you apply, is tremendous impact on a case. So the harmless error rule is what applies here. So even if there was an error, even if both sides admit that there was an error, it is let's say, conceded that an error occurred. If after the case is finished, the record is reviewed, the law is applied, if after all of that the error is deemed to be harmless, then there will be no reversal. If harmless error is okay. You may like that, you may not like that, but just keep in mind it's harmless error. So there is some cover here, even if a mistake was made on law enforcement's part, if it turns out that it was harmless error.